Good morning, everyone, and welcome to another episode of North Alabama Law Review presented by Johnston and Weston. I'm your host, Shauna Hill, and today we have the attorneys joining us, Bennett Driggers and Christopher Weston. Good morning, guys.
Morning.
Well, today, guys, we're going to jump into our trending topic of firearms. So Alabama recently passed a bill. The bill is SB 119. And this bill is aiming toward enhancing public safety and expanding restrictions when it comes to firearms to try to keep our community a little bit safer. Chris, we know you are an advocate for firearms, so would you like to kind of give us some insight on this bill?
Yeah, definitely, happy to do that. Some of it I've dealt with, some of it I've not at this point. But I will tell you, a lot of these have been in place in one form or another for a very long time. And, as much as I tend to be, pro Second Amendment, which I definitely am, some of these restrictions make sense. And, there are some of the very few that I actually do support. Such as if you are convicted of a felony, you are not allowed to own a gun, okay? And that means in your home, you're not allowed ownership whatsoever, not just an inability to carry, it is also a bar on ownership. And that is something that makes sense. I mean, if you've committed a felony and, kind of gone through that route, that, the whole criminal process, been convicted of that on the criminal side, and they decide, they've decided, and this has been this way for a long time. I don't know what exactly they amended in it, but it's been that way for a long time. I mean, there's actually a subsequent crime that comes into play if you are someone who's previously been convicted of a felony and you are found in possession of a firearm. So that's actually a different charge, felon in possession of a firearm, or certain persons forbidden from possessing a firearm. It's another felony. And like I said, it's one of the few gun control laws or, restrictions on gun ownership that make sense. Engaging in that type of criminal activity at the felony level, it's shown as or deemed, and it's been argued, moral turpitude at that point, or being, shown to engage in violence against, other people illegally, is what allows your firearms rights to be restricted. There's been some pushes recently in other states, and I believe in this one as well, for after a certain period of time after a felony to be able to get your firearm rights back. You can do pardons. You can, it's a process through the governor's office to try to get all of those rights back. Firearms rights, voting rights you'll get back pretty quickly, because you also lose your voting rights if you are a convicted felon under the same kind of thoughts that you've abused your rights as a citizen. Therefore, some of them are going to be restricted so you cannot harm others with your choices. That's the basic mentality argument that has, passed those types of laws in the past and, continue it forward. And again, abusing your rights as a citizen to that extent, to a violent extent, to a felony extent, there is some logical backing for it.
Well, let me kind of pick your brain about that for a second, because one of the things that it mentions when reading about the new bill is that if you are released but your trial is still pending and is from a criminal charge, that now you are prohibited from having a firearm. Has it always been that way, or is that truly something new that we should keep in mind?
Well, I mean, as far as that goes is, I've not actually seen that section of this law put into play. I've not actually seen that yet. So that is actually news to me when I've been looking at this. But it's always been a part of it. If it's domestic violence, usually there's, one of your bond conditions is going to be turning over your firearms. I mean, it's always been that way, unless you have some reason not to, like a police officer or some, security guard, some reason like that, that it's always been a bond condition. And, that deals with the discretion of the judiciary, that when they're setting a bond, or when a bond is set, meaning for pretrial release, that they can lay out certain conditions. Obviously, one that's always there is do not commit any more crimes, right? And avoid dangerous circumstances and injurious people. Go to work. They can impose a reasonable list of conditions on your release. And whenever there's domestic violence, the one of no, you're not owning any more firearms for a little while is usually one of them. Now, as far as it being for other types of felonies, other types of charges, I've not seen that yet, outside there being some kind of attendant circumstance, or should I say, I've never seen it enforced. And that doesn't make a lot of sense for that to be an automatic, just because you've been charged. I mean, there's a lot of constitutional issue with that, and I'm not entirely certain that that would stand up to muster to make that automatic, okay? I'm not sure if maybe that was challenged and struck down at some point. I've not seen that. But as I said, I've not seen it enforced, just as a general rule. And you need to think about, and those of you watching at home, you need to think about, you've not actually been convicted of anything yet. It can be a false charge. It can be something you didn't do. And now, within the realms of taking reasonable precautions on putting someone out on bond, you have a right to bond. And so that just because you're out on bond, that doesn't automatically mean you have that the state has the right to limit a bunch of your constitutional rights. That's not how that functions. Because again, think of it this way, a felony is, fraudulent use of a debit credit card, right? Well, you're restricting someone's right to carry firearms because they're accused of misusing a credit card. That doesn't make a lot of logical sense to add those two together automatically.
Makes sense.
Yeah, and so it shouldn't be automatic is what I'm getting at. And I'm sorry, guys at home, we're sitting here thinking through it, because a lot of these laws that come through are going to be challenged, or portions of them are going to be challenged. And so enforcement can, take a little while on provisions that may have a constitutional question. You don't want to rush a bunch of appeals or, mandamus motions to, the appellate courts or the Supreme Court on something that really has a question as whether or not it'll pass muster.
Thank you. Bennett, would you like to add anything?
I would. One of the things to think about in this realm is there are also federal laws that prohibit possession of firearms that looks like Alabama's trying to mirror some of those with these changes. So keep that in mind. If you have a question regarding that, by all means, take precautions, contact an attorney, get the answers you need. You don't want to be caught with another charge while your current charge is still pending, just because you're carrying a firearm or own a firearm in your home. And it also includes deadly weapons. When you talk about restrictions for convicted felons, a deadly weapon can be a crossbow or a bow, something you normally would hunt with, but that's considered a deadly weapon, and you give up your rights to, or you lose your rights. You don't freely give them up, but when you commit a crime and you're convicted of a felony, you can lose the rights to own any of those types of weapons. So be very cautious. If you have a question, by all means, contact an attorney. Don't just look online, because you're going to get mixed reviews, mixed answers, and half the time, bad information. So don't depend on that. Give somebody a call and check your rights.
Oh yeah, I cannot tell you how many times we get questions along those lines about what you're allowed to do or not do. Especially, some of the funnier ones where it's like, well, I might have a girlfriend who might own a firearm that might be on my side of the bed. And it's like, look, you start layering hypotheticals, you're walking into a problem, okay? I mean, yeah, some of those are valid, and some of those things you can do, because if it's not yours and it's not near you and it's not your ownership and you happen to be there, there are levels of that. However, when you start layering hypotheticals, usually you're putting yourself into risk and you know it, okay? So just be very careful when you start trying to find ways around prohibitions like that. I mean, significantly.
And what the legislature is aiming for here is safety of the general public. They're not trying to restrict people who lawfully have a right to possess or carry or whatever. They're looking at things, they've upped the charge on shooting into an occupied dwelling. And occupied dwelling can be, as the code describes it, a train, car, different things. But anyways, they've upped it from a Class B felony to a Class A for firing to an occupied building, which makes sense because that's a dangerous event and they're trying to protect the general public. Hopefully none of you that are listening have this problem, but it's just make you aware that as the legislature goes through these types of bills and looks at them, they're looking to protect the general public. And that's the whole premise of these updates. They're changing some of the crimes that you can get denied bail on if there's a firearm involved. They've changed the legislation to be able to deny bail based on that for certain types of crimes. So it's all based on protecting us, the general public. So don't take it as restrictions on law-abiding citizens. That's not the purpose.
Yeah, and you know, this being our trending topic, you know, that's very important, is that there is a significant difference between limiting firearms and types of firearms and firearm usage and ownership for law-abiding citizens versus those who, at least through the judicial process, you know, especially when there's been a full jury trial by, you know, 12 of their peers, have shown that they are willing and able to violate their rights as a citizen. You know, especially when it comes to other citizens. Like, there is a difference between being law-abiding and not, at least when it comes to firearms, because again, it's one of your rights as a citizen. If you've shown you're willing to abuse those at the expense of others, that's what I'm getting at. Being willing to abuse those at the expense of others is a different thing than just owning them in general. Yeah.
Thank you, guys. And, you know, in Alabama, we have a lot of people who carry firearms here. So if you are maybe pending trial or maybe have a couple questions regarding your rights on carrying your firearm, if you are in a position, definitely contact our office. You can ask for Mr. Driggers and Mr. Weston, and they'll be happy to meet with you and educate you on further on your rights and what you can and can't do regarding this matter.
Yeah, and you know, again, this being one of my passions, I do want to add this in there as well, as if you are charged with something, you know, there are ways to fight it. There are ways to argue it. You know, we're talking about convictions, and what comes to mind are things like when you intentionally engage in murder, okay, or something along those lines. You know, if you are charged with something and it's wrong, or maybe even it's right, but you shouldn't be convicted of it, you know, call a lawyer. We're definitely willing to help.
And it can be misdemeanor in the case of a domestic violence charge. At that point, you are not allowed to have a firearm until that case has been resolved. And if you are convicted, then you're not going to be able to own a firearm after that. So lots of different scenarios. We don't have, you know, the time to go through every one of them. So like Shauna said, give us a call. We'll help you out if you have questions.
All right, guys, thank you for the information. So now we're going to get into the questions segment. Today, we're going to start off with a probate question. Bennett, this is your area of expertise.
Oh, yeah,
here.
no, it certainly ain't me when it comes to probate. No, thank you.
So our first question says, my siblings, my cousins, and myself have inherited property from our grandparents. However, everyone is not cooperating. What should we do?
Wow, never seen that before. No, that tends to happen, especially sometimes there's generations that have just skipped. The deed controls on that. So if there was no will or anything, but the deed usually says, okay, to me and my spouse and I with right of survivorship, and then to our heirs and assigns. Well, heirs and assigns covers a lot of areas. Like with this question, you could have ownership from lots of cousins, second, third cousins. It just depends on the number of generations that have passed since that something's been done with that land. So what we have to look at is we have to look at it in terms of, once we see what the deed says, then we go to the laws of intestate succession and see what order property were to be distributed after that. But we see this a lot when people cannot agree. So there's a recourse out there, and it's you file a petition for sale or division with the circuit court in the county where the land sits, if you cannot agree. And you know, one thing to keep in mind when you do that is that costs the estate money. And what I mean by that, when that land is ordered to be sold, should the parties not agree, then there's fees associated with that. One is the fee for the auctioneer. The court may appoint an auctioneer to auction the property. They're going to get a percentage of the sales price when that goes to auction. The second is the attorney's fees. The attorneys don't get involved for anything. Now, the person who files it, that attorney can get paid out of a certain percentage of the estate. If it sells for $200,000, they're going to get a certain percentage of that. The auctioneer is going to get a certain percentage of that. So as all this happens, and some of the other heirs might hire an attorney, so there's all this money being spent that might take all the equity out of that property by the time that sale is over, and everybody's going to end up with nothing per se. So be careful. Try to work things out if you can with those you're in disagreement with. You know, it's not worth the litigation, but there again, it's hard to get two people to agree sometimes, much less a group of people who really, even though they might be related, don't really know each other half the time. So, you know, keep in mind that there is a process for it, but it's going to cost everyone involved money because it's going to be taken out of each person's share, all those fees and everything, and then what's left will be divided. If it's $100 and you got 5 people, hey, you get $20. Good luck.
Sounds like it's more rewarding if everybody plays nicely.
It is. It's definitely more rewarding. So keep that in mind.
And you know, I can't believe I'm actually going to chime in on a probate question here. You know, it's an interesting morning. But you know, for people at home, and Bennett, I know you deal with the probate stuff all the time. But for those of you at home who don't know, I see Bennett working on these things. The reason it costs so much, and the reason that there's, you know, so much, you know, again, loss a lot of times when families are fighting, is it is a lot of work to sort it out. You know, think about it in terms of if you've gone sometimes decades with these individuals, either not getting along with them, not knowing them, and then we have to come in, or anyone has to come in and try to sort out generations worth of basically family neglect. It takes a while. It is a difficult thing to do. And Bennett, you're a master at it. But yeah, it is quite an endeavor. A lot of times it really is.
All right, well, let's go ahead and jump into our next question. Chris, this one will be a great one for you. It is going to be in regards to workman's comp. So this person was recently injured while lifting heavy boxes after the warehouse's pallet jack broke. The employer had not repaired the equipment for weeks and insisted that the employees manually lift instead to complete their job. Says I have, the person has a herniated disc from having to do the manual lifting, but the employer is not wanting to do an accident report or help the employee in any way. What are their rights and what should they do next? Okay,
so this definitely falls squarely under workman's comp. And there are several things here. First off, be aware, for the person who brought this question up, be aware at home, they don't have an option on doing that first report of injury, okay? That is something they are required to do by the state. They do not have that as an option. They're not doing it, which means they are in violation of the statute, okay? They're in violation of the law. So the way that this works is that, you know, workman's comp, as the statute says, it is the one recourse that you have in just about every circumstance. There are a few exceptions, but they are very, very few. I've maybe seen it once or twice in the past, I don't know, 10 years or so. But what you get for that being one recourse as an employee is the fact that it doesn't really matter whose fault the injury is. You were injured at work. Now, you've added a few extra facts in here regarding the employer not fixing a pallet jack, ordering employees to move things by hand. Now, we would need some more information on that. And what I mean by that is there's obviously OSHA laws. There are a lot of, you know, federal and labor laws out there that deal with, you know, how certain things are moved, what they have to provide, safety equipment. And if one of those has been violated, then that might be a separate claim either through an administrative body or, maybe something that can be added into the lawsuit itself. But to get to as far as your actual injury goes, what you're dealing with is a workman's comp claim at its heart. Okay, there may be some ancillary claims you can make because they didn't provide safety equipment, lifting equipment, ordered you to do it is without a pallet jack. So it's questionable, and we would need a little bit more information on that part of it. But at the workman's comp heart of it, put them on notice of the injury. I know you've already done that, but what you need to do is put it in writing, put it in an email, a text message, a carrier pigeon, it doesn't matter. Something proving you gave them notice of it. And then if they do not take the next step, get you to a workman's comp doctor, pay you, for being out while you've had this herniated disc, depending on how severe it is, whether or not it's full, what's called temporary total disability, or some portion of your lost wages if you can only do light duty, and so you're not making as much. They need to start those payments. They need to get you to the doctor. And if they don't, you need a lawyer to file a lawsuit, okay? And the reason you really need a lawyer on that one, that's really, workman's comp is not something you want to do yourself as far as a case goes, because it's purely statutory. Like, there is very little common law, very little common sense to it. It is literally dealing straight off the statute, and unless you have read that statute and know that statute, you're going to have a very hard time pressing your own claim. And so what you need to do is put your employer on notice in writing, make a demand for medical treatment, make a demand for appropriate relief under workman's comp, and if they still refuse, you need to come see an attorney.
One thing to keep in mind is this scenario gives you an unusual circumstance that was out of the realm of their normal duties. But keep in mind that normal duties, if you get hurt, if another employee is horseplaying and hurts you at work, you were at work. So that's a workman's comp claim. So there's other scenarios. This is an unusual example where something had broken down and you were required to do more physical labor than normal. That still applies, but just your regular duties, if you're on a line and you do repetitive motions and you suffer injury because of that. So there's other things. It doesn't have to be a special circumstance. So keep that in mind.
Yeah, absolutely. Any work injury is 99.9999% of the time going to fall under the workman's comp statute. And my guess is that even the one that you had with this pallet jack would probably be a pure workman's comp claim. Again, there may be a little bit extra there just depending on the specific facts there, like what you were lifting, what was in those boxes, and what the requirements are. Like, again, if it was nuclear waste in that box somehow, there's gonna be extra laws involved, okay? So there may be something else, but yeah, Bennett, you're absolutely right, so, okay.
All right, thank you guys. I'm going to squeeze in one last question. So this one's going to be more on the landlord-tenant side, which both you guys do practice heavily in. This one states that they have a tenant who has not paid their rent and is now 20 days late. They are not in default until the 30-day mark. However, this person would like to know what steps they can take to try to get them to pay or evict them at the soonest date possible if they do not pay.
You want that? You want me to take it? Either one of us can do that one.
No, I'll go ahead and start. Essentially, don't take the law into your own hands. There are guidelines in the Landlord-Tenant Act that you have to follow, you must follow, in order to properly evict somebody or put them on notice. So it's 7 business days notice. If they're behind on rent, you can give them 7 business days to cure. If they don't cure, then you do it. But now that's once they're delinquent. I don't know why in this scenario 30 days is the magic number. Most landlords require payment within the first 5 days of their late fee. So once they're late with the rent, you can move forward with those notices to get them to cure, or you can start the eviction process.
Yeah, absolutely. I'm sorry, Bennett. Am I stepping on your toes
No,
there? 'Cause I was ready to
I
jump
looked
in.
at you because I knew you were ready.
Okay, yeah, no, I'm ready to go. So what you're talking about is what it sounds like, and again, I'm speculating a little bit here. It sounds like you have a lease that allows them a 30-day grace instead of that 5-day grace is what it sounds like. And so, they're not actually delinquent until that 30th day. And then, like you said, Bennett, 7 business days, you have to give an appropriate notice with a right to cure and then begin the eviction process. If you're trying to get them to pay beforehand, you can send other reminders. And I see this a lot with a lot of my landlord clients, is what they do is they, we'll send a reminder, say, look, we're, not going to give you extensions past those 30 days. Like, you need to pay now. You are, the rent is owed. You can't say it's late because it's not technically late. It doesn't sound like under your lease agreement, but you can say, like, we are not going to give you extensions and passes going forward. Like, if you hit that 31st day and you are in fact late, we are going to put in the notice, the right to cure, with the right to a cure. So that gives them 37 days before they evict, or before you have a right to evict. But what you're dealing with there is that you can give them reminders and you can let them know, like, past what's required in the law and the lease, I'm not going to give you any further extensions. If they know that they're actually on a time frame that they're not going to be able to skirt around, a lot of times you will get some kind of movement from them. Yeah.
Okay, thank you guys for answering these questions. And we thank you guys for tuning in to North Alabama Law Review. Again, if you want to submit a question, please submit it to legalhelp@JMMT Law Firm. We'd love to answer it on air for you. Guys, did you have anything else you want to add before we go?
Yeah, I've got a couple things. Oh, Bennett, shoot.
No, go ahead.
You got it. So for those of you at home, the format that we have, we generally like to just cover a trending legal topic. But if you put in a ton of questions that are varied and different, and you'd like to see it, we're more than happy to just do full legal questions for an entire episode. So that's something we've been looking at. And so at the tail end of this episode, if those of you at home have some to submit or things you're just interested about, it doesn't necessarily need to be something you're going through. So again, if you are just curious or would like to have episodes along those lines, please let us know at the Legal Help email. And we look forward to seeing you next time. Thank you.
Yeah.
All right, thank you guys. Have a good day.